that he had previously agreed to provide without compensation. And it appears, though, is not entirely clear that the decision to close the railway line to the public was made by the County Council, hence the reason why people were writing to the County Council and not the Crown. It is far from clear that the Crown converted any road to a railway or closed the railway to the public. But Māori did write to the Crown. They wrote to the Native Minister in February 1878, saying they'd been allowed to travel on the road and that it was used as a railway, that had been used by the railroad until September 1877. And their complaint concerned the closure of the railway line to the public, not the original taking of the land for the road. There is no evidence that the public road that came to be used for the railway line was ever a Māori track. The closest that I can see at all in the evidence is a comment in the letter from Māori to the Native Minister where they refer to our road. And I've already said that Māori wrote the letter to the Native Minister. The letter was written by Māori. It was written by Mahi Kawiti, but it was also on behalf of 99 other people, and we don't know who the 99 other people were, and whether, for instance, as the Crown would submit as likely, it included non-Māori, and I say it's likely because at this point the issue doesn't seem to be a Māori issue. It's an issue of the locals, Māori and non-Māori. And in that letter they refer to our old road. But the Crown would submit that it's a real stretch from that one single reference to infer that, therefore, that was Māori land or a Māori track. I'd like to take members of the Tribunal now to another part of the submission. I'm just going to take the Tribunal through some examples in particular. I'd like to take the Tribunal to page 30. And 2/3 of the way down the page at my para 94, there's a heading, Takings at Kamo Hekurangi. The generic closing submissions state the total compensation of £1,296 was assessed for 88 acres for this railway line, and that compensation of £30 was assessed for 7 acres of Māori land taken from the Parakiore number 2 block, and that a settler that suffered the taking of only 2 acres received £150. And there are issues with these statements as I set out in writing.
Mr. Irwin, can you remind us what legislation that was taken under? Was it the 1928 Act?
No, because I think we're back at the end of the 19th century here, because we have reference to events of 1894.
All right, thank you.
The Crown notes that Mr McBurney states that this assessment was from a schedule dated 8 April 1894, and so the assessment comprised the, as we took Mr McBurney to be saying, the amounts of compensation that were awarded. But that couldn't have been a decision on compensation payable because it predated the taking, which was some 7 months later. And the Crown having reviewed the document that Mr. McBurney was referring to, it appears to be an internal Public Works Department list of valuations of lands to be taken, so it's just a potential at that point. And so we just don't know what the final compensation was. So it's incorrect to say that the settler was awarded £150 in compensation, and the other statements there.
Can I just stop you there? Because one of the things that's often said is that from 1880 onwards, or 1882 onwards, we have two different systems of government powers and responsibilities in terms of public works takings, one developed for Māori land and one developed for non-Māori land, and that the overall impact of that tended to be that Māori received less notification and had less powers of consultation, and indeed received less compensation for land taken. And so, do you have a comment on that?
Yes, I do. And the crowd's going to boo at me, but it really is a case of going through it case by case. And I think the best example to look at, because there's the most information there about it, is the Kaikohe aerodrome, which I will take members of the Tribunal through. And the claim there is that land is taken both from Māori and non-Māori, and the claim is that Māori land's not only targeted, but there's an unfairness in the levels of compensation that are paid for. And I want to go through that in some detail to show that that's not the case, that there are objective reasons why compensation that's paid to Māori is paid at an appropriate rate and equivalent rate. It's paid. There are the different systems, but the requirement is to pay a market rate for both. And so the duty is to assess a fair market rate for both Māori land and non-Māori land. So I think, I think if the Tribunal is looking at claims of a general nature in this inquiry, that generally speaking Māori land was either targeted or that Māori were unfairly compensated, you'd have to have a sufficient base of examples before you to actually show that that happened in fact. I cannot point to one. And in fact, I can point to examples where an objective basis and a proper market value was assessed for both Māori land and non-Māori land. And of course, different lands have different economic values, and you've absolutely got to realise that. I mean, we'll come to it with the Kaikohe aerodrome, but there the European land involved had objectively different things on it that went towards its compensation. There were different improvements on the land, different, I think, fences and buildings that went towards the compensation that was awarded there.
And if we look at the issue of notification, do you see any sort of structural problem, if you like, there?
Well, that's different, isn't it?
What's another aspect, that's another criticism that's often made of the two different streams that apply for almost 100 years, I guess. Yeah, and
it's a problem that follows from the multiplicity of Māori names on titles and the issue as to whether those records are indeed accurate and up to date, and the ability of government particularly the Public Works Department, to be able to locate those people. There are real practical difficulties for the Crown. I think the Crown has to accept, doesn't it, that the practical difficulties tend to stem from the individualisation of title.
Yes, thank you. Thank you.
And so the notification procedures that result, for instance, getting in touch with the district land board, I think were practical measures taken in a best effort to try and to get in touch with the people who would be best able to notify owners.
Yes, so sometimes the impression is that they didn't actually try all that hard. And
just coming back to this example, at my paragraph 96, the actual amount that was awarded by the Native Land Court was in fact more than double the amount suggested by Claimant Council, and it wasn't £30, it was actually £63.
Kia ora, kia mau.
I'd like to just keep moving through my page 33. And I'd like to bring up something on the screen at this point. I'd just like to bring up the generic submission of Claimant Council. It's 3.3.211, and the paragraph reference is 261. I think that's on the screen, and so this is the heading here is Urupa e Korokota, and the paragraph relates to this taking, and so does the next paragraph, and then the claimant generic submissions go on to another issue. But what the claimant generic submissions say is that the taking of land for railways from the Okaiho and Rangihua blocks included an area of Urupa located at Korokota, and it took a specific request from Muriwai Hepehi, where the names of soldiers from the Northern War who had been buried there, to have an alternative considered. The district engineer noted that there is no difficulty in altering the line, and so the request was in this case accommodated. However, there was still no compensation. So if everyone in the room would like to put themselves in my shoes, having received this, I'm wondering, do I infer that there must be something wrong with the taking of this land for it to be mentioned in the first place, I assume, and so I'm looking for the wrong. And there seems to be an issue around the fact that there's an urupa here, and that there's no compensation taken. Now the footnote 195 is to Mr. McBurney's report, and so I'd like to go there, and this will only take a moment. So the document reference is A13 and to page 295. Now, just looking at this, this is Mr. McBurney's section on this area of land that is taken, and the urupa. And it spans this page 295, it goes over the page where we have a map, and goes over to the next page, 297. And it's clear, if we start at 295, that that there's a proposal to take land for a railway line, and it's identified that it's going to go through an urupa, and this is identified. Muriwai Hepehi and another writes to Tauhenare, saying, we respectfully request that the railway line be not taken over our cemetery, e korokota. There are certain persons who are buried who fell in the Heke War. And then if we go over to 297, at the top of the page, Mr. McBurney records that the district engineer was asked to report on the matter, and he said, essentially here, yes, we can alter the line of the railway, which is a big thing for a railway, but we'll alter the line of the railway so it doesn't go through the urupa. And this happens. And so I'm at a loss at this point to understand the criticism of the Crown at this point. And then we come to the issue of compensation, because my learned friends say in their submission, still no compensation for the land was taken as the submission. And again, the footnote of the submissions is to Mr. McBurney's report. And having just taken you through Mr. McBurney's report at this point, Mr. McBurney doesn't say that. And I think that's a good point to end for lunch, perhaps.
Before we do end for lunch, can we just follow through? Because I just wondered, I realise you're looking at this specific case, but in general, if the Crown did take urupa, would that be seen as a treaty breach?
Potentially, and I think it would depend on the circumstances.
And would you say the same if it was reserved land?
By reserved land, you mean any land reserved for Māori, obviously?
Can we just hold the noise? We need to hear the answers.
Yes, because
Polina, turi.
I was thinking of the Moko block that we were talking about yesterday, where there was a 200-acre reserve left out of that whole block, yes. And eventually that is taken to be added to a forest, I think, by the railways company, or taken to protect the forest. And the fact that this is the tiny piece of land that is left out of quite an extensive tribal estate, and that ends up being disposed of by a Māori land board without informing the owners, seems a regrettable chain of events, if I put it that way.
Again, I think my answer is potentially, and it will depend on the individual circumstances.
All right, thank you.
We will go to lunch, but just before then, are there any matters from Council? Ms. Peters, did you have any matters you want to raise regarding your birthday or anything like that? Danny? Happy birthday. We'll come back at 1:30. Kia ora.